Beastie Boys. Today on Lawyer Flash. Welcome to Lawyer Flash, where we explain the law. I'm your host, John Deere. Every day there's law bouncing around in media, in government, and it's affecting you. I'm here to explain it all. This week, the Beastie Boys got into a copyright dust-up with toy maker Goldiblox. This story received massive press coverage, and we're going to go further than the press and explain the law.
You got a problem with that?
The Beastie Boys are a best-selling, irreverent hip-hop band from the 80s and 90s. Goldiblox is a toy manufacturer that specializes in manufacturing toys to empower girls. As part of a clever promotional, Goldiblox rewrote highly empowering lyrics to the Beastie Boys' misogynistic hit, Girls. It turns out the Beastie Boys had a career-long policy of not using their song for commercials.
Beastie Boys.
They felt so strongly about it that the now dead Beastie Boy, Adam Yauch, had a provision in his will that the songs would never be used for commercials. Beastie Boys had their high-powered lawyers send a letter to Goldiblox saying, "What the f***?" Goldiblox claims they have a right to use the song as a parody. Goldiblox filed a suit for declaratory relief against the Beastie Boys. That means Goldilocks filed a suit saying, "We think the Beastie Boys are going to try to sue us and stop us from using this song, so court, please tell us, are we allowed to use this song as a parody?"
What?
Activists on both sides of the argument immediately lined up, itching for a major copyright brawl. On one side is the recording industry, who presumably would like to see this kind of use limited. On the other side is the Electronic Frontier Foundation. Naturally, the Electronic Frontier Foundation supports Goldiblox's use of the parody version of this song. So what is the law? This is a copyright issue. Copyrights protect writings, the written embodiment of songs, designs, software, and other written embodiments of ideas. Copyright does not protect the ideas themselves, just the written embodiment of them. You may not use a copyrighted work without permission. A big exception to copyright protection is the fair use doctrine. Under some conditions, using a copyrighted work to create a parody is fair use. The dictionary definition of a parody is an imitation of a writer or artist's style or content with exaggeration for comic effect. But the law is not a dictionary. The courts have a four-part analysis to determine if a particular use is a parody. What is the purpose of the new work? Was the original work a creative work? How much of the original work is used? Is the new work likely to affect the marketability of the prior work? The surprise is, after filing their lawsuit for declaratory relief, Goldiblox changed their mind and withdrew the song, putting a new soundtrack on the video. Most industry experts believe that Goldiblox would have won the lawsuit, but it would have cost them a lot of time and money to get there. As for the Beastie Boys, they said, "We didn't sue anybody. We just wrote you a letter asking why you were using our song. We like what you're up to." That's our show for this week. You can find us here each week at youtube.com/lawyerflash or lawyerflash.net. And remember, subscribe, subscribe, subscribe. You can also check out our Facebook page and our Twitter feed. I'm your host, John Deere. We'll see you again next week on Lawyer Flash.